Hello, everybody. Hello, everybody. Welcome, welcome, welcome. Welcome to the live. Welcome to the live. It's been a while since I went live. And my channel has really grown a lot in the last few months. And if anybody out there who is joining me is from a subscriber from the Karen Reed trial, the Donna Adelson trial, welcome. Thank you so much for your support. I had so much fun covering those trials, clipping those trials. There were such interesting cases. And it really gave this channel a boost. I mean, I've got so many new subscribers and everything from that, and I'm really looking forward to continuing to cover trials like that. The last one I did was Alicia Andrews in Florida, and always looking for a good case to cover. There's a lot of trials going on right now that I'm kind of keeping an eye on. None have really grabbed me enough to want to do the clip everything like I did with Karen Reed, Donna Adelson, Alicia Andrews. But I want to keep doing that. And I thank you all for your support, your subscriptions, your views. I know people have been commenting and passing around the channel and everything. So I think that's great. I haven't been doing, obviously I haven't been going live lately, but I want to get back into it, kind of test this out, because next week we've got a big trial going on in Miami, Florida. I'm actually going to be going out to Florida from Los Angeles to cover the trial. It's Megan Thee Stallion's defamation lawsuit against an online commentator who works with StreamYard, or excuse me, Stationhead. I'm on StreamYard right now, but she works with Stationhead, Milagro Cooper. She's being sued by Megan Thee Stallion. Case has been going on for a little bit, and it's actually is set for trial. So I'm going to be going out to Miami next week, and I'll be in the courtroom. It's not on video. It's in federal court. So there's no cameras allowed. It is an exception in that courthouse in that they do give media credentials for people who, so you can use your laptop in court. I can't transmit from court, but I can take notes. So that's a big help for me just professionally. It's a lot easier to take notes on a computer than it is to have to take notes by hand and then write a story when you get out of court. So I'll be able to do some good coverage on that. And I want to go live because I know there's going to be a lot of interest in that trial, and so many people are want a video update, somebody who can tell them what was the courthouse like, who was in the courtroom today, who testified. It's one of those things where it's a civil case, so I don't think Meghann is not required to be there, but I do certainly expect her to be there. Both Milagro and Meghann are going to be there, and I would expect them both to testify. Again, where they don't have to, but I would expect testimony from both. So that's going to be big to watch. And I've got the link there below for legalaffairsandtrials.com, but my Substack, I'll be sending out updates on that. I want to do a preview story of it, kind of lay the groundwork for the trial. That I'll be doing that, sending one out this weekend. So, but if you guys go on there now, you'll see my coverage of the appellate ruling in Lanez's case. Tory Lanez is the rapper who shot Megan Thee Stallion more than 5 years ago now. But his appeal, like all criminal cases, pretty standard to have an appeal in a California Court of Appeal after like a LA Superior Court or Superior Court criminal conviction. And we finally had the ruling. There was oral argument in August, and they issued their ruling yesterday, 46 pages, and it rejects everything. I mean, this was completely expected. If you just followed the trial and kind of knew something about, appeals and how those work, you knew that he really had no chance at all. There were just no issues here that would give rise to like a new trial, a remand for sentencing, or anything like that. But then when he actually filed the opening brief, it was like, okay, he really has obviously no issues here. So this just kind of affirms everything we already knew. But thank you guys for tuning in too. Thanks for saying hi. Thanks for saying hi. Everybody say hello. Say hello. Hey, Meg, what's going on? Yeah, thank you. You're welcome, and thank you guys for tuning in for the live. Like I said, I haven't been going live in a while, but I am going to be getting back into it, especially next week with the trial in Florida. I know everyone's going to want updates on that. So, yeah, so many trials happening lately. The beheading one, the Devin Michaels, the porn star, is accused of beheading her boyfriend in Las Vegas. I've been keeping an eye on that one, and it looks like the teenager who was accused of murdering his parents, his adoptive parents, is testifying right now. So I was going to keep an eye on that one too. But lots of stuff going on. But Meg, that's me. Yeah. Regarding the case in Florida, I think she has it's going to be a really interesting case, way more so than like a criminal case, because it kind of breaks new ground on defamation law against online streamers. But it's also a lot like Cardi B's lawsuit against Tasha K. So it's kind of an extension of that. But I think we're in for a good trial for sure. Queen Megan, thank you. Hello, everybody. Thank you. Yeah, and Milagro, that's one thing. If people are familiar with the Alicia Andrews case, Jeremy McLyman, I think I'm pronouncing his name correctly. He's representing Milagro. He's based in Miami, and yeah, so it'll be interesting to see how that all goes down. Yeah, thank you, Mother Bob, real journalism. Yeah. Yes, and yes, I answered that. Obviously, I'm going to be covering Meghann versus Milagro. That should be after I read the appellate ruling and just thought about everything. Like, man, this is going to be a good trial, because I think they definitely have a case against her. But then just the fact that when I think anytime you hear about this, it's like, well, doesn't somebody have the right to still say they're innocent? And just because somebody's convicted at trial, I mean, does that mean that if you say that you still think they're innocent, you're defaming the victim? And I think that is like kind of the initial issue that's like strikes people. But as anyone who's like heard Milagro rant about this, it's way, way deeper than that. And her comments go way beyond that. And the lawyers are making the case that this goes way beyond any kind of fair comment or anything. So I'm going to be kind of I've been kind of, there's just been so much, there's always so much back and forth. And I think Twitter is such a toxic website, and it's really, really dying down too, in terms of like influence. So I've really just tried to get off there, and I've just had a bunch of other stuff going on. So I am a little behind on all the filings in the case, but I'm going to get caught up because I want to do a preview story and everything for the trial that starts, I guess, with jury selection on Tuesday, and I should be able to be in there for that. But Tory Lanez's appeal, the appellate ruling, the 46-page appellate ruling. Here, I'm going to link it in the comments. I think that'll actually show up for you guys. But I've got an article on it that has a link there, and like I've said earlier in previous slides, like it's very common that the appellate court will find errors that happen during trial or sentencing. But the big question is, are they reversible errors? Here in this case, they barely even found any errors. And the errors that they did find, one was a jury instruction issue. They ruled the jurors, Judge Hereford should have read a different instruction regarding the concealed weapon charge, carrying a concealed weapon inside a vehicle. And he should have read one that specified you needed criminal intent for it. But they said that was, that it was harmless because there was so much that outweighed it. And there was a lot of talk and argument that emphasized he needed criminal intent, like intent, state of mind to be convicted of that. So they thought that was a wash. But I mean, if that's like the only thing that they won, I mean, that's not gonna really move the needle on anything. They basically rejected everything. And it is true that I said this on Twitter, that when you actually look at this, and I've known this all along, that his appeal was freaking terrible. I mean, it was really, really, really bad. Crystal Morgan doesn't know what she's doing. It's true. And I'm sorry if it's like considered rude that I say that or something, but it's like, we're in like the participation trophy era where, like, you know, just because you tried hard and turned in the appellate ruling, we're not allowed to like call it terrible and incompetent. It's like, I mean, it's not like if he really had any issues, but one thing that jumped out to me is the aggravators for his sentencing. And I posted about this on Twitter. He only challenged one aggravator to his sentencing, and the judge found 4. One of them probably maybe was challengeable. It was the aggravator of his post shooting conduct. And it's like, where in the statute does it say that the judge can apply that? But he never even challenged that on appeal. So the one that he did challenge was Meghann being found a vulnerable victim. And the argument that Crystal Morgan put forth on that was that Meghann had to have known, or she had some knowledge that there was perhaps an armed individual in the car, so she had time to run or flee. I mean, these are incompetent arguments. I mean, somebody says here, literally a joke. It's like, yeah, no, seriously. It's like, what is this? And somebody on Twitter was like, this is like the biggest sign that we live in a stimulation. It's like, seriously. And all these grifter, like the state representative in Florida, of course, and then Diana London, that PR person who like latched on to Lanez and his family. It's like, okay, now they're just being victimized. Like, I mean, this lady's just ripping them off, And I guess the big question is, did she charge them any money? But I mean, his appeal never had any chance at all of going anywhere. And the idea that Gavin Newsom is going to pardon him is just completely ridiculous. And it's one thing if they're just doing all that out of the goodness of their heart, they're just volunteering, or it wouldn't be out of the goodness of their heart. They would still just be doing it for the publicity. But the big question for me is, are they charging? Which I'm pretty sure they have to be charging money. People don't just do that for free. So that would make it wrong. Yeah, so I'll pull up the actual ruling here. But one thing I told my lawyer friend that reading through it kind of underscores how uninteresting his appeal actually was. Like I said, I mean, he had no real issues in here. And the real story is how incompetent all his filings were. But it's really just kind of a boring read because, like I said, there's no real, interesting legal issue established or anything like that. But I see Roots and Reggae saying, where will you go live during Meg Mill trial? I'm not totally sure. I might do it outside the courthouse, maybe during the lunch break, but I'm going to be staying like kind of near the courthouse. So maybe I could go back there during the lunch and do it. I kind of got to get a feel for the setting and everything there, but definitely after the trial ends, like do like a nighttime live recap. That'll be great. And then also send out a Substack with like notes on the trial and the witnesses for the day for sure. So they determined that eight errors that Lanez alleges occurred in his trial and sentencing are not actually errors. And they identified one error when they determined the jury should have been instructed differently regarding the concealed unregistered firearm in a vehicle charge. But they also determined that on this record, the court's failure to do so was harmless. And they indicated that there might have been some ambiguity regarding the instruction about great bodily harm, just like what is great bodily harm? How do you find that? But they said it was harmless because it was obvious. It was substantial evidence established beyond a reasonable doubt that the injuries Peterson inflicted on Pete were more than moderate harm. And to me, that it just underscores how divorced all the online commentary and all the hatred against Meghann is from like reality and how this was going to like actually play out. It says, the justice said, indeed, they are more properly characterized as significant or substantial harm. They said her testimony about her pain in physical therapy, as well as testimony from a surgeon who removed bullet fragments from her feet, was more than sufficient to support the jury's finding that Peterson personally inflicted great bodily injury on Pete. Seriously. I mean, the idea that any of that was ever going to like fly in an appellate court, it's just weird. And I think it's a good indication of how the trial could go. Like I said, it's going to be a really interesting defamation trial because it is your just initial reaction to it is like, well, I mean, Lanez has a right to still say that he's innocent, and people can support them and say that they think the jury got it wrong. But obviously the argument from Megan's lawyers is that this goes way beyond that. But I think this is a good indication of how the jury could go against them pretty hard, Milagro pretty hard. The one question though, when you're dealing with a celebrity like Meghann, though, is always damages. It's like the jury could find liability here, but then, not want to award a lot of damages. But if you look at, especially, I mean, Milagro has been so vicious and nasty in her podcast, and she's talked a lot. And when you actually read some of this stuff, it says, it's all about, they talk specifically about her record sales, her concert stuff. It's all about her career. And I saw a comment today that I was like, well, that could just be like evidence in this defamation trial for damages or something. It's all about how, this is just going to follow Meghan around for the rest of her life. It's going to affect all her relationships, et cetera, her career. She's never going to be this big, blah, blah, blah. It's like, yeah, I think this is all stuff that her lawyers are going to be pointing to in trial. I don't think we're going to see that actual tweet because it's about Milagro, not about just random people on the internet and everything they say. But I'm quite interested. It's going to be a good trial. I knew it was going to be a good trial before, but yesterday, just kind of reading through everything, I was like, oh man. Somebody asked if I remember who Kelsey's lawyer was. Yeah, I remember what he looks like. What was his name? Like Daniel. I think it starts with an N is his last name. He does a lot of criminal cases in LA. I see him around. But yeah, the case was so long ago too. And all the idiots online who are like, oh, he has, Supreme Court and he can petition federally and stuff. It's like, yeah, he can do all that stuff. It's not going anywhere. The SCOTUS, a petition to, it'd be California State Supreme Court, that'll get rejected. They're never going to review that. And then the idea that any kind of federal habeas petition would, first of all, go anywhere. No way. But that's also a pretty long process. And he's he's eligible for parole in 4 years. It's like September 2029. So I'm not quite sure what the process is, like how they'd go through that. But one interesting thing in Milagro's case is I've seen stuff, and I got to really get into the filings, but I've seen that Meghan's lawyers have said stuff in the filings about how they want Lanez to serve more time in prison because of this. And I don't see how that's possible. I do not see how it's possible for any kind of like federal civil case to ever add to someone's actual prison sentence, either in federal court or state court, unless they're going to use this in opposing any kind of parole for him. But I'm not sure how he could get actual more prison time for that. But we'll see. I thought that was an interesting request. It's definitely not good for any kind of hope that he has for like early parole or anything like that. Because it's in 4 years, so we'll see what happens. But it's like he was sentenced to 10 years, and they're not going to be able to keep him any longer than that. I don't think. I'm just interested to see how Quinn Emanuel goes about this. We're trying to get Tory Lanez more time in state prison in connection with his actions here. We'll see if they have anything more that they're going to file or anything like that. But the ruling, like I said, I went through here. It's unpublished, which is basically just something for lawyers to understand. Obviously the opinion is still public, but it doesn't establish new case law. So it's not citable in other cases. Technically lawyers can cite whatever cases they want to, but they want to cite establishable case law. And if there's any kind of legal issue that they think Lanez's opinion addresses, there are many other published opinions that already better establish those legal issues that they can just cite from there. So that's what unpublished means. But so yeah, there were arguments about Meghan's testimony, jurors seeing photos of his tattoos, testimony about his probation case in Florida, which I guess wasn't actually a probation case. It was a diversion from a criminal case, and jurors hearing prosecutors' pretrial interview with Meghan's now former friend, Kelsey Harris. It also says Hereford didn't err when he allowed prosecutors to use as evidence an Instagram post from the Shade Room. I think a lot of people have seen and heard about that post where Tory Lanez's Instagram account replied, "That's not true," to someone saying, people saying Kelsey shot her with a crying emoji. And that was ruled fair game. The article gets into more at the bottom about why that is. They mentioned Kelsey again, and I thought this was good where Lanez, to any kind of like layperson who's not just like brainwashed by all these morons on the internet, he's pretty obviously guilty. Their arguments against this just don't work. And this Sean Hawley stuff is just like, it's completely out of left field. There are conspiracy theories about like why she was forced off the case. And the justices are the ones who I don't think the email where Sean Hawley says that she has reservations, or she doesn't think that blaming Kelsey is a viable strategy. That wasn't a big part of the appeal. That wasn't mentioned a lot, but it was included as an exhibit, and the justices saw it. They looked over everything here, and especially this argument about why Sean Hawley left the case. The idea that it was somehow prosecutorial misconduct for the prosecutors to wait and tell her about Kelsey's bribery allegations like at the last minute, so she would somehow have to be forced off the case or something like that. It's just totally kooky out there and not supported by anything. And the justices were saying, when you actually go in and look at the evidence that they do have, it shows the reasons for her departure. And one of them is that she didn't think blaming Kelsey was a viable strategy. So overall, I mean, the opinion is just up and across the board, a series of L's for Lanez. Like I said, the real story in it all is just how bad his appeal was. It's not like if he just had, a better advocate, or if they'd argued this a little bit better, he would have gotten a new trial or a new sentencing or something. There just wasn't really anything to go on. But I mean, this was like exceptionally bad appellate advocacy. And it kind of raises the question of Unite the People, that group that Crystal works for. They charge inmates to do this kind of appellate stuff. And again, it's a big question of how much are they actually charging these people? Because if they're charging these inmates any money to put forth these kind of appellate filings that Crystal Morgan's putting forth, I think the inmates are getting ripped off. But, it's just kind of a private decision that they make that we don't really have access to. It's not like you can file a public records for this. But remember, they already rejected 2 habeas petitions back in August that sought an evidentiary hearing or new sentencing based on alleged new evidence. And that was the stuff about, the driver's statement supposedly coming forward, and also all the DNA testing, all that nonsensical argument about the DNA testing violating industry accepted standards, even though Lanez's own expert spoke to it all. That was all rejected back in August. So remember, we do have video of the appeal up that you guys can watch. I mean, it was just obvious from watching the appeal. Like if they were considering overturning a criminal sentence or ordering a new trial in a case like this, they would have been asking a lot more questions than they did. But they didn't ask hardly any questions. It was obvious how it was going to go. But and part of it is I know it's just part of the kind of campaign that they're waging against Meghann, that anything like this they want to amplify online to increase the Tory Lanez's appeal is going places, she's in trouble, that kind of thing. But an offset is that some people actually really do believe this. There was a serious group of his supporters that really did seem to believe his appeal had a chance, and it was just like, oh God, that's like a crime in itself to dupe those people into thinking that. But will he be deported? I'm not sure. I guess I would say yes, because he's Canadian and he now has felony convictions, but that's not really an area of the courts that I would cover. And I think it's just kind of up to what's the immigration landscape in a few years. But yeah, I think it's definitely going to present problems for him once he gets out. So again, I've got this linked on my Substack, which you guys should subscribe to. With my YouTube channel exploding, I'm obviously been focusing on that more, but I want to kind of integrate them when I'm covering a trial like Alicia Andrews or Donna Adelson's trial. I want to send out like a daily Substack that kind of rounds up the testimony for you all. But so subscribe in there and get it going. But the big thing, one issue, and I went through each issue kind of, this is what the court said, and then I explained their ruling here. The trial court, which would be Judge Hereford. They don't actually name Judge Hereford in the ruling, but anytime they're referring to the trial court, that would be him. Said he didn't abuse his discretion in permitting the prosecutor to ask Pete, that would be Meghann, questions directed to her inconsistent reports to police and her attitude about the case and about testifying. And that's the thing. The idea that the prosecutors couldn't ask her about, how are you feeling today, or why are you feeling, the way you are? It's like her demeanor is, jurors are actually instructed that they can consider her demeanor and when addressing her, assessing her credibility. So those questions were completely fair game. And the justices observed that Lanez's lawyer in cross-examination repeatedly asked her to admit that she'd lied. So it's and that was lied in the interview to like CBS News about whether she had a relationship with Lanez. And so obviously that's all fair game for a trial. So Evidence Code Section 352.2, and this is the Creative Expressions Act regarding Lanez's tattoos. He had argued about the rap lyrics, but he'd also argued that there was a photo of him in the police booking station. There was a photo of him, there was a photo of Kelsey, and there was a photo of Jaquan that the police had taken that were shown to the jurors just to show them how everybody was that night. And Lanez has his shirt off, and you can see a gun tattoo on his chest. And it was pointed out during cross-examination by Alex Bott, the prosecutor, of one of the detectives. So the appeal argued that was his conviction should be reversed because they saw that photo and there was emphasis on the gun. Like I said, this is not actually like a serious appellate argument when you see this. I mean, when I sent the ruling to a lawyer friend, I said, there is some stuff in there that would seriously mortify any like normal appellate attorney who cares about looking competent. But that's, I don't think, really what we're dealing with here. But the court ruled that photo was, of course, admissible. It's not. And actually, not only was it admissible, they said that the argument about 352.2, because it took effect on January 1st, 2023, and there's already a California Supreme Court ruling just on August 28th, actually, in a separate case. They ruled that law isn't retroactive. So that means that Lanez's argument on this whole thing is dead in the water just based on that, because he was convicted on December 23rd, 2022, and the law took effect, after that. So he can't argue it for anything. But they said that despite that, the argument, the record doesn't support any kind of argument that the photo of his tattoos injected racial bias into his trial. And they said there was no gang allegation in this case, and no one ever suggested that Peterson had any gang ties. The prosecution offered Exhibit 18 and Exhibits 19 and 20. That would be the photo of Kelsey and then the photo of Quan. And the court admitted them into evidence solely to show the identity of the individuals who officers swabbed for gunshot residue at the police station. And so Crystal Morgan, and when I say Morgan, that's who I'm talking about, Lanez's appellate attorney, also argued that Bott, the prosecutor, improperly referenced the gun tattoo when he was questioning EJ in cross-examination. But justices pointed out that Lanez's lawyer is actually the one who asked if Culberson had ever seen Peterson with a gun. And so that's when Alex Bott on cross-examination was like, you see that gun tattoo right there? And the justices said neither of the prosecutors even mentioned Peterson's tattoos, much less the tattoo of a firearm, in their closing arguments. And that's the thing, it just wasn't a big deal at trial. Like, it says, justices also said Megan's brief reference to Lanez making a music video chopping up Horace's legs was permissible because it relates to her attitude about testifying. So the 352.2 issue also came up again for Lanez. That's the new law regarding creative expression. He was saying the rap lyrics, that Judge Hereford had indicated that prosecutors could question him about lyrics and music videos that he wrote. They take it on a case-by-case basis, but that if he testified, that could be fair game. And he was arguing in his appeal that impermissibly chilled his right to testify. And the biggest rejection of that from the appellate court in this argument is that he didn't testify, so he can't raise that issue. If he had testified, he could raise the issue of it was unfair of them to be able to question me about these music videos. But because he testified, they can't weigh the merits of a judge making a decision like that, whether the judge abused his discretion by saying he could be questioned about that. So that right there ended his argument. There's some talk about this U.S. Supreme Court ruling that I kind of get into. Like I said, I mean, it really wasn't a very interesting appeal. It just kind of was a chore to write about, and kind of realized that, I mean, Twitter is a really toxic website. Like I said, I think it's pretty much dying and going away. But if you just get off that website, all the bots and the kind of people that he has trained for this go away. They're not there. And like I said, he's running out of options here on what he's doing. And his camp has got to maybe hopefully realize that they're not being well served by these state reps and wannabe PR influencers who are taking their money. So hopefully this will kind of die down. And I think the Milagro trial is going to be a big test of that. I mean, if she gets a defense verdict, that's going to be big for her. I mean, she's going to feel emboldened. But if she gets hit with some kind of big verdict, that could be big. So I think it's going to be, like I said, that's going to be a really good trial. But the mention of Peterson's criminal case in Florida was not prejudicial. So justices said that testimony about Lanez being on probation in Florida didn't unfairly prejudice him because prosecutors elicited it after his lawyer implied in questioning that Meghann falsely told police Lanez claimed to be on probation. Lanez actually was on diversion for a criminal case in Florida. And remember, all Meghann testified was that Lanez told them that he was on probation. He said, like, after the shooting happened and they were in the car, he told them, like, you guys can't say anything. I'll give you all $1 million if you don't say anything. I'm on probation. So whether he's on probation or not was like kind of irrelevant. I mean, he was on a diversion, and like you'd hear somebody say, "Oh no, you can't say anything. I'm on diversion." Like, it doesn't mean that he didn't say that he wasn't on probation. But during trial, McDesian, Lanez's lawyer, actually stipulated with prosecutors after that happened that jurors be instructed that diversion and probation are not the same. You are not to speculate about the circumstances of Mr. Peterson's grant of diversion in 2017. It was terminated in 2017. And you are not to conclude from this evidence that Mr. Peterson has a bad character and that he's disposed to commit crime. So remember, McDesian's whole point on questioning Meghann about that, like to try to cast doubt on whether Lanez actually told her he was on probation, was just to question Meghann's credibility. Their whole case rode on jurors just not believing Meghann, and it frankly just wasn't a good defense. It works on the internet, and it works on all these people who to this day like viciously harass her and say that she wasn't shot. But it's just on the people outside of this like kind of world that they're in, it's not a very persuasive defense. So it's going to be really interesting to see what the whole what Milagro's kind of narrative is in trial. If they really try to go hard on the Meghann lied and she wasn't actually shot. I mean, I think that would be a terrible idea, because that's the thing. I mean, Meghann was obviously shot. I mean, they had an orthopedic surgeon testify about removing bullet fragments from her feet. So, and I saw some of the deposition transcript clips from Milagro where the Quinn Emanuel lawyer is asking her about the fact that she was in the courtroom when that orthopedic surgeon testified and talked about removing bullet fragments from her feet, yet she's still going on her show and implying or saying that Meghann wasn't actually shot. And I think that's what gets into malicious intent, where, you know, Milagro is not just asking questions in trying to have a good faith debate about whether this happened. She's saying stuff that she knows isn't true. At least that's going to be the argument in trial. So, I mean, I have a feeling that this could go very badly for them, but I don't know. It'll be interesting to see how it is. And I'm looking forward to seeing jury selection and everything. But, so the justices wrote, Pete's testimony that Peterson said he'd been caught with a gun before was not false. Justices wrote in the new opinion. In any event, Peterson's counsel reached an agreement with the prosecution to present a stipulation with the true facts to the jury, and for the court to instruct the jury on what diversion means. The record does not support Peterson's claim of error on this point. And then their next finding was the trial court did not err in permitting the prosecution to play for the jury as a prior inconsistent statement, the recording of Kelsey Harris's interview with prosecutors. And this is one thing I found interesting, because my remembering of the trial and how this went is Alex Bott wanted to play the entire recording after he said that Meghann unfairly implied in his prosecution that prosecutors were trying to unfairly influence. They were trying to pressure Kelsey. So to try to counter that, he wanted to play the entire interview. And it seems to me that justices are establishing in this ruling that the prosecutors could have played it anyway because she was denying her statement so much. Kelsey was. That's what I read this. I mean, the idea that they couldn't have played Kelsey's interview was always not a viable argument. But I think Crystal Morgan was arguing something about, you have the right to confront your accusers in court. And her argument was that, well, because they played this recording, Meghann didn't get a chance to cross-examine Kelsey about it because, he wasn't at that interview and he couldn't ask her any questions. And it's like, okay, that is not like a real legal argument, and no like competent appellate attorney would put that forth, especially if they saw how the trial went, because Meghann did ask Kelsey questions about that interview. I mean, he was the one who was like really bringing up the interview and his crossover, asking all sorts of questions about it. He had the interview in discovery and knew the contents of it beforehand going into trial. So he was prepared to ask her questions about it. I mean, the idea that the confrontation clause is somehow violated here, it's just, that's why you don't even see anything about that in the ruling, because it's just a dumb argument. That it's just, there's all these reasons, and they're pointing out that there's a reason beyond that. This absolutely was a viable thing to hear. And frankly, when you read the way the justices wrote it, you can tell that the idea that Kelsey was being truthful on the stand when she said she couldn't recall all this stuff, or she doesn't remember seeing Tory with a gun or anything like that, that is not believable to like a normal person outside of their little like brainwashed internet realm. Like the idea that it was ever Kelsey's recant on the stand was going to somehow mean that Lanez would be acquitted. It's like, probably not. I think the jurors know what's going on, but justices were writing that, Kelsey repeatedly claimed not to remember what had happened that early morning and in the days following the shooting. But they said jurors are allowed to consider prior statements, such as Kelsey's interview, for its truth, as well as for the light it sheds on the witness's lack of credibility. She said, so the prior statement has a dual purpose. It may be considered for impeachment as well as substantive evidence. And that's kind of the first time that I've really seen that argument put forth, or that fact put forth in this case. It's like, it wasn't just to impeach Kelsey. It was to show the jurors actual evidence of what happened in this thing that prosecutors are trying to prove. When a trial court concludes on substantial evidence that a witness's professed lapses of memory are false, evasive devices to avoid truthful answers, it may admit as inconsistent the witness's prior statements, describing events the witness now claims to have forgotten. So that's a case law. They're quoting some case from 1996 when they do that. And I do have Kelsey's interview linked in here if anybody wants to hear it all. And their next finding is that the trial court did not abuse its discretion in admitting evidence regarding an Instagram post. After jury selection, prosecutors moved to admit a "that's not true" comment Lanez's Instagram made in reply to a comment on, I should add an A in there, on a post from the gossip powerhouse, The Shade Room, that said people saying Kelsey shot her. So Morgan argued on appeal that prosecutors improperly disclosed the post late and that it shouldn't have been admitted at all under evidentiary rules against hearsay. And the new opinion says Lanez forfeited the timeliness issue. That's the you disclose this late issue, because he didn't object during trial. And then justices also said that any error in admitting the post was harmless. They didn't find that the post shouldn't be admitted, but they just said if it shouldn't have been admitted, it was harmless, because as Judge Hereford noted when rejecting his motion for new trial, it was an extremely minor issue in the case. And I thought this was good. And I should highlight this on Twitter. This would be a good one. It says, the case turned on Pete's testimony, Peterson's admissions to Harris when he called her from jail. Exactly. Like that recording of him calling her and profusely apologizing to the woman that he then turned around and tried to blame for the shooting in trial, that was so bad for him. Like that, yeah, there you go. So And then also, as somebody who watched the trial, it was pretty well established that it's very possible Lanez is not actually the one who typed that comment on his Instagram account, that celebrities have people who control their social media for them. So it's not a given that Lanez is the one who typed "that's not true." It could have been somebody else doing it for him. So yeah, the idea that he was convicted based on that is ridiculous. He wasn't. So the trial court said, or the appellate court said, there wasn't anything to see there. It said their next finding was that the trial court, which remember that's just Judge Hereford, properly instructed the jury on count 1 in the firearm enhancement. Any error in the instructions on count 2 was harmless. So this is where they did get one win, even though it's not really a win when it doesn't do anything for your client. And the justices also say that your argument was somewhat difficult to understand, somewhat. But said she didn't cite case law to support her assertion. Oh, I thought this was funny. When you actually read it in the ruling to it, it punches. And this is an example of one of the findings where I told another lawyer that there was some stuff in that ruling that would seriously mortify any attorney who cares about looking competent. But they say that Morgan didn't cite case law to support her assertion that assault with a semi-automatic firearm is a general intent crime, yet the enhancement attached to this count requires specific intent. And justices said, no case has held that assault with a semi-automatic firearm or personal use of a firearm enhancement requires specific intent. I mean, they're like, where the hell is this lady getting this from? I mean, it's like, okay, yeah. Moving on. Justices said Morgan's contention about the instruction for count 2, carrying a concealed firearm within a vehicle, requires more discussion. So they're indicating, yeah, there is an issue here. And forget getting into... They get into all the details in the opinion about which actual instruction Hereford read and which he should have read. But they said that Hereford should have instructed jurors that the crime requires the specific state of knowledge instead of only general criminal intent. Except they say on this record, the court's failure to do so was harmless. Yeah, I mean, the idea that if the jurors somehow, falsely convicted, or they wouldn't have convicted Lanez if only they'd been instructed differently on this carrying a concealed firearm charge. But Hereford instructed jurors that prosecutors had to prove Lanez had wrongful intent and knew the gun was in the vehicle. And then Bott, in his closing argument, argued in closing that Lanez knew the gun was in the car. He's like, of course he knew the gun was in the car. He just shot Meghann with it. And McDesian also emphasized the need to establish intent by arguing that Lanez didn't even know the gun was there. And so the justice said, in short, the jurors were well aware that the prosecution had to prove Peterson knew the gun was in the vehicle. And they're quoting a 2016 Fifth Circuit ruling that says jurors are presumed to be intelligent and capable of understanding and applying the court's instructions. And remember, if for some reason they had ruled that was a harmful error or prejudicial, it probably would have only affected count 2. It's not like his assault with a firearm would have been overturned. And then they said any ambiguity in Calcrim number 3160 is harmless in this case. And that's the jury instruction regarding great bodily harm. And again, I got into this in the top of the story, but any ambiguity about that instruction is harmless because substantial evidence established beyond a reasonable doubt that the injuries Peterson inflicted on Pete were more than moderate harm. And I just copied and pasted the ruling here. People can just read it. But the prosecutor's statements in closing argument do not require reversal. And this was another just weak, not real argument that Crystal Morgan put forth. But she said that Alex Bott made improper comments during closing argument that warrant reversing Lanez's convictions. But judges said the claims fail on the merits. As we explained, the prosecution's questioning of Pete about why she initially lied to medical personnel and police, the criticism directed at her after she accused Peterson, and her attitude about the case and about testifying was not improper. Reference to that testimony in closing argument was not improper for the same reason. And so one issue they also raised, Crystal raised, was, and they addressed this in the oral argument back in August, but the propriety of Bott telling jurors in his opening statement that he expected Megan's former security guard, Justin Edison, would say that Lanez implicated himself in the shooting. The new opinion said it's not uncommon for counsel on both sides to tell the jury that a particular witness will testify, only to be unable ultimately to procure that witness's appearance. Because remember, Edison never testified. So part of Lanez's appellate argument was that his entire conviction should be reversed because Bott told people, influenced jurors in his opening statement by telling them Edison would implicate Lanez, and he never did. But justices weren't having that. And Bott also suggested that Lanez tried to bribe Kelsey, and justices said that's not improper. I mean, remember they tried to charge Lanez with witness intimidation during trial, but got some emergency vehicles passing here. So Pete testified that Peterson said don't tell on me, and I'll give you all $1 million if you don't tell on me immediately after the shooting. Should get rid of that quote. Harris said the same thing in her September 2022 interview with prosecutors. Harris also told prosecutors she'd met with Peterson outside a hotel a day or two after the shooting, and he asked her if she needed a job, if she wanted to work with him. He also mentioned investing into a business, and that's based on her September interview. And they note that though by the time of trial 3 months later, she changed about why Peterson offered her the money. Equivocated. Prosecutors may argue inferences from the evidence, according to the opinion. When attacking the prosecutor's remarks to the jury, the defendant must show that, in the context of the whole argument and the instructions, there was reasonable likelihood the jury understood or applied the complained of complaints in improper or erroneous manner. Peterson has not made that showing here. Yeah, that was just not a viable argument, ever, really. So justices also rejected Morgan's argument that Bott improperly denigrated defense counsel, and the justices called the trial vigorously litigated and hard fought. In sum, none of the prosecutor's statements constituted deceptive or reprehensible methods that were reasonably likely to have affected the outcome of the proceeding. And this is their stuff about Sean Hawley, which we covered above. But the idea that Hawley was somehow pushed to withdraw from the case because prosecutors waited until trial to accuse her of bribing Kelsey. It says Peterson's wholesale failure to support any of these assertions with citations to the record is telling. And it says, then this is when they get into the Kelsey not a viable defense. The letters and emails Peterson himself attached to his new trial motion show the reasons Hawley did not try the case and ultimately withdrew. 1, she was engaged in a lengthy 7-month arbitration. That's the Trevor Bauer, Major League Baseball pitcher accused of sexual assault arbitration. 2, she was not comfortable with the defense blaming Harris for the shooting. And 3, after Harris's statements were introduced at trial, she concluded she had a conflict. Nothing in the record supports Peterson's allegations that prosecutors opted to lull Hawley into a false sense of security by deceptively assuring her they did not believe her to be involved, according to the opinion. And then the trial court, Judge Hereford, did not err in imposing the midterm. And this is the most, this is one that really underscores how just bad his appeal was. He really had no chance of ever overturning his sentence, because remember, prosecutors wanted 13 years and Hereford only gave him 10. So Hereford really did not give him any room for an argument on appeal there. And he did a whole bench trial. It was like a 2-day sentencing where he decided all these aggravating and mitigating factors, and then just basically ruled they were a wash and sentenced Lanez to a sentence that doesn't require any aggravators. So even if the judge or the justices had found that some of these aggravators that Hereford found, the 4 aggravators, were erroneous, it wouldn't have changed the sentence. It would have been a harmless error. But I will say it is amazing that Morgan didn't challenge the aggravator of Lanez's post-shooting conduct. It seems like if any of the aggravators, that was maybe one that he had a chance with, but they didn't even challenge it. The aggravators were use of a weapon, his post-incident conduct, the vulnerable victim, and his eligibility to be sentenced for extra time for his gun conviction. The only one that Lanez challenged on appeal was the vulnerable victim finding. And this is one where you read, it's like, okay, Crystal Morgan is not like a serious appellate attorney. Their argument that Meghann wasn't a vulnerable victim was that she knew of a possible gunman in the car and had the ability to run or duck once she saw a gun being pointed at her. It's like, okay, that is not like a real argument, but they actually did put that for us. So, so the justices found no error on that. But here's the thing. They said, moreover, even if that were not the case, no resentencing would be required. The middle term, so 10 years, not the 13 that prosecutors wanted, was the presumptive term. The court was not required to rely on any aggravating factors in selecting the middle term, and Peterson does not dispute the presence of 3 of the 4 aggravating factors the court identified. All the trial court was required to do in selecting the middle term was to state its reasons. The court did that here. So here I am now discussing the ruling. Oh, and here's the federal defamation trial preview. That is one thing I'm looking forward to doing, another Substack that kind of gathers all the documents and gets it together. Like I said, it's an interesting case, and it's tough to know how it could go. One big question is damages, and I'm just really interested to see the whole scene. I'm so excited, and I'm stoked because, like I said, I have a pass that's going to allow me to use my laptop in court, so be easy to take notes. I'm not going to be live tweeting. They don't allow transmission from the courtroom, but I'm definitely going to be able to take comprehensive notes on everything, so it should be good. Thank you so much, Playgirl, for saying hi. And yeah, and somebody says Herbert, for any serious lawyer would laugh at this. Yeah, I mean, it's like, and I don't want to, it's tough to focus too much on the incompetency of his lawyer, like on Twitter, because I don't want to imply that, like, if for some reason he just had like a better lawyer, you know, he would have a new trial and a new sentencing, because he just did not have any issues at all. But it's like, at least he probably could have put forth an appeal that was a little less embarrassing. Like, what the hell? but anyway, guys, I'm almost been going for an hour here, but again, I'm so happy everybody tuned in here. I'm going to be doing more lives next week. Like I said, I think that's a good way to update everybody on the trial next week in Florida. And then everybody who's, you know, happening to pop in from, who knows me from covering the Karen Reed or the Donald Adelson trial. Again, thank you so much for all your support and all your views and all your subscriptions on that. Those trials were so big, and it's so interesting, and it was great to be able to share it with all with you. And I want to do more with this channel. You know, I want to get more, now that I have more resources, I want to get people together to help me put together videos. Like I would like to put together more professional videos of me talking about court rulings, like this Tory Lanez appellate ruling, that kind of thing. So I want to keep doing that. So everybody, give me a like, give me a subscribe, go to my legalaffairsandtrials.com Substack to subscribe, and I will keep in touch. Remember, I'm putting together a preview article on this big defamation story, so I want to get you guys all up to speed on that, and then I will see you guys next week from Florida. So thank you so much, and yeah, everybody say hi. I'm reading your comments here. You're all so nice. So watching from South Africa, I love it. Yeah, the Milagro case is going to be interesting. And you are welcome. Thank you guys so much. Have a good night. Thank you.